Welcome back. Now, Public Protector Advocate Busisiwe Mkhwebane on Friday filed an application asking the Constitutional Court to reverse its earlier impeachment judgment that paved the way for her impeachment. Now, in her affidavit, Mkhwebane raises constitutional errors made by the court in its ruling on the case that was brought by the Speaker of Parliament and the Democratic Alliance, and she wants the order to be set aside. Meanwhile, Parliament's Section 194 committee has revised its timeline and processes leading up to the impeachment of the Public Protector to now meet a September deadline. The committee was established by the National Assembly last year to conduct a constitutional inquiry into the fitness of Mkhwebane to hold office. Committee Chairperson Qubudile Dyantyi joins us now virtually to have a further discussion on these matters. Mr. Dyantyi, thanks for your time. Welcome to Morning Live.
Morning, Sakina and your team, and morning to all Morning Live viewers.
So, firstly, just your reaction on the latest developments, because it would seem that the Public Protector in her latest battle seems to be questioning the procedural rather than substantive issues in this particular development.
No, Sakina, this process and the National Assembly, there's one thing that I think is overarching on our side. We have a major weapon, which is fairness and rationality. If my answer to this, you'll have to go back and understand that the Public Protector challenged the rules when they were set up, and had about 10 issues that she said must be set aside when addressing the panel. The panel found none of those in her favor. And when we started the process, she challenged and went to the Cape High Court, raised a dozen of issues about that, in both Part A and Part B, interdicting. She didn't succeed in interdicting the process. And out of those 12 issues, it was found in her favor only in 2, the legal representative and as well as the issue of the judge. We now, when we then appeal to the Constitutional Court, the Constitutional Court found that the rules were sound and constitutional, and that secondly, we erred on our side as Parliament for not allowing her legal representative, which we anticipated that it's something that we might have to deal with, but it was never going to derail us. But on the issue of the judge being part of the panel, the Constitutional Court, which is the highest court in the land, found that there was nothing untoward that in fact the rules were constitutional in that regard, and in any case, the recommendations of the panel are more advisory, that the National Assembly does not have to rubber stamp that. Hence, there would be a committee of Parliament that would investigate, make findings, and give kind of reasons. This is the latest of, and I want you to read the trends and patterns here. Now she has a half a dozen reasons that she is, in this case, not appealing, asking the same court, the highest court, because you can't appeal. There's nobody, you can't appeal beyond it, to ask them to rescind their own decision. And she makes 6 points out of those. I think that the Constitutional Court will be well in its right to decide on this matter. I would not speculate around that. But as things stand, our process has not been interdicted. We continue with our process. We started after a very long pause, given these kind of challenges. We resumed our work on the 22nd of February. In fact, when we started, she would have written letters, more than one letter, asking us before the 22nd of February to hold, because she is still thinking in 10 or 15 days' time, she might apply to the Constitutional Court. We proceeded because nothing in law, and there's no court interdict that stopped us from proceeding. We then adopted the terms of reference and the schedule of activities that I can briefly share with you.
Let's talk to that, because as you rightly say, the public protector in her affidavit does point out to the fact that she is aware that a constitutional court judgment cannot be appealed. But as you pointed out, half a dozen reasons that she comes up with, and she says these are patent and or ambiguity with regard to what has been arrived at. And so she wants the Constitutional Court to rescind that judgment. Let's talk to that, and also what sort of bearing, if any, that would have on your work.
Two things, Sakina. First, when you ask the court, and it's not only the Constitutional Court, could be any court, when you ask them to review their own decision or rescind it, that rescission has to follow certain guidelines, and there must have been kind of granular errors in law or facts that they would not have considered. You don't just rescind, ask the court to rescind their judgment because you don't like their judgment. And again, I'm not going to get into those merits. I will leave that to you and experts that can deal with that. But in terms of the impact it would have to us, we have patience for this process. We after the pause, we then decided to continue. The only impact it would have would be to stretch a bit of our timeline, perhaps beyond September. But as things stand, Sakina, we have a date with the public protector. The date we have with the public protector starts from the 31st of May. And we hope that by then, things would have been sorted out in this process. Because by the 31st of May, it's going to be her first appearance with the committee. And there would have been a lot of things before that. Because from the 24th of February to 24th of March, we are sourcing out an external expert in terms of the evidence leader. And then we're going to get next week on the 29th, we're meeting again as a committee. And then we get into placing evidence in front of the committee that we'll share with her as part of letting the other side know what you're doing. So we have a three-pronged approach, a preparation phase for this and the actual hearings. The actual hearings will start with witnesses at the beginning of May. And by the time we meet with her, we would have seen and interacted with witnesses. And the third aspect will be when we wrap up and write a report. And even when we write that draft report, before we endorse it, we'll give her a month to read the report that would have made findings and recommendations about her on. So we're very rational, want to continue to be fair in the process.
Mr. Dyantyi, you touched on this a short while ago. The second part of last year's judgment, it ruled that rules needed to be amended to allow the head of a Chapter 9 institution to have legal representation. Now, has the committee already amended the rules to accommodate that?
We're proceeding well in that regard. That has been done, Sakina. Firstly, it starts with the Constitutional Court made a reading kind of clause which assisted us to say this is how the rules must read as part of the judgment that they have made. And that issue, as I would have said to you in July 2021, that on that issue, it is only going to be applicable when she comes in front of us, and that it's an issue that would remedy. It will take us a week to do, but that's already in order, as I indicate. And part of our roadmap now and the schedule, the fact that we're sourcing out this external expert, has been influenced by that kind of a judgment, because it now means that we've got to get the best of who we can get, because the roles are more kind of expanded than initially anticipated.
So there are many respondents cited, including the Speaker and political parties, as well as civil society organizations. So as parties still have to respond, do you have any knowledge at this point, Mr. Dyantyi, whether Parliament will be responding?
of course, Parliament will oppose the rescission because Parliament is of the view that there's no basis for that rescission. It is our own decision that we appeal to the Constitutional Court about, and therefore we still stand by those reasons because the Constitutional Court found in the favor of the National Assembly, and we think that the Constitutional Court made the proper and the right decision in this regard. So we're definitely going to oppose this rescission application by the Public Protector.
And then, Mr. Dyantyi, I suppose just to bottom line it, so given what the Public Protector is asking for, this rescission application, does this force the committee in any way to wait for the finalization of this particular legal issue? And how does this fit into your initial draft program timeline? Because as you said, initially you were meant to end at the end of January this year, and you were expected to table a report before the National Assembly. It's now been extended to September, but given these new developments of the Public Protector's Constitutional Court application, do you anticipate that the process will now take longer?
The process may take longer, depending on, obviously, how soon the Constitutional Court makes a judgment in this regard. I anticipate if they would have the same speed as they had with the rescission of the former President Jacob Zuma, our September deadline would not really be affected. As I said, we are in March now. We only expect to interact with the Public Protector in May. And hopefully by then, things would have been cleared out of the process. So there may be delays. There might not necessarily be delays, but whatever happens, Sakina, as we were ready in July 2021, we're ready today. We'll be ready by the time that the Constitutional Court makes its judgment on the matter, because we think that this is an important matter. It is important for the Public Protector's Office and herself to have this matter speedily attended to and not have an issue hanging around, because what is not going to happen is for us not to do. This is an exercise in accountability. It's our role as oversight body and as Parliament to do this. There is no amount of delays that is going to make us stop doing this and testing this fitness to hold office. And this is a new process. We're on pioneering ground. It's a first of its kind, and we want to do it right. We want to be squarely within the law when we do this, but we're so focused and determined that it must be done.
As you say, Mr. Dyantyi, this is pioneering, and also the impact of this on the Office of the Public Protector. What sort of damage do you think has been done to the reputation of this office, given this whole process and everything that's played out around it?
To understand that extent of damage, one has to read the motion itself that has brought us here, because in the entire motion, every issue that is being cited there, and it's quite a multiple of reputational damages, whether it's your CR17, it's your Fred Dairy, is your SARS matter, the Absa Bank issues, everything that is in the motion by now has already determined and says to us, the sooner we fix this, the better, because that office has got to be assisted to recover from all of these reputational damages, and it doesn't seem to be stopping, Sakina. And that is why we have to be determined to assist this Chapter 9 institution in terms of its integrity and the reputational damage that it has so suffered, continues to suffer.
Well, we'll have to leave it there. Thank you so much for your time this morning. Mr. Qubudile Dyantyi is the chairperson of the committee that will conduct an inquiry into the fitness of Public Protector Advocate Busisiwe Mkhwebane to hold office. And the committee has now revised its program, as you heard there from Mr. Dyantyi, extending the process until the end of September, which will, of course, include responses by the Public Protector before it drafts its report and tables it before the National Assembly.